Lee Siegel, representing Marine Systems. I'd like to reserve 6 minutes for rebuttal.
Sure.
This case is brought in state court, the underlying case, for a breach of contract and unjust enrichment. And defendant moved for summary judgment in this case on the grounds that the issues has already been litigated in a prior case, which was tried in federal court. The lower court judge granted the motion for summary judgment, and we believe that was an error. The first case that was between these two parties came about as a result of a bait and switch allegation by the plaintiff against the defendant, that the plaintiff had ordered specific parts manufactured by a specific manufacturer, and the defendant represented to the plaintiff that they would receive those parts, but upon receipt, the plaintiff started to doubt the genuineness of the parts. After some discussions between the parties, the first case was filed back in 2011, and the first case was actually filed in state court by the plaintiff. The defendant moved to remand the case to federal court, which they did successfully, and the case proceeded in federal court. During the course of the case, there was discovery, depositions, and there was 5 counts in the first case. The first was for breach of contract, and the specific breach of contract that was alleged was certain parts were ordered, those parts were not delivered. There was a count for fraudulent misrepresentation, fraud in the inducement, and unjust enrichment as a result of the fraud. In other words, you're giving me parts that are worth less than the parts I actually ordered, so you're being unjustly enriched by the difference of what you charged me and the difference of what you sold. As trial approached, the plaintiff filed a motion for leave to amend the complaint. That was denied by the court. The plaintiff also filed a motion for extension of time to conduct additional discovery. That was also denied by the federal court. The plaintiff then attempted to dismiss the case without prejudice, which the court again denied. Under the federal rules, you can only do that before an answer has been filed without leave of court. So when you move to dismiss without prejudice in the federal system after an answer has been filed, you have to get leave of court. The court denied that motion to dismiss without prejudice, and as a result, on August 30th, 2012, the plaintiff filed a dismissal with prejudice. Now, the defendant's position in this case is that dismissal with prejudice is on the merits. Therefore, anything brought in a subsequent case based on the same contract must be res judicata or an improper splitting of actions. And that's not the case here, because on the merits means that the issues were fully adjudicated by court. And that didn't happen. So what we have...
What is then the difference between dismiss without prejudice and dismiss with prejudice?
Well, with prejudice does mean you cannot come back on the same cause of action. And while the second complaint has 2 causes of action, breach of contract and unjust enrichment, they are referring to a different breach. In other words, the second complaint says, we returned parts to you for credit, you were supposed to pay us money back and you didn't, and therefore we would like the money back. That claim was not right at the time the first claim was filed. And so the plaintiff could not have filed the second, the issues raised in the second complaint at the time the first complaint was filed. The leave to amend was not granted, so we don't know if it could have been tried in the first case because the court refused to grant leave to amend. And so at that point, if we look to the case law in Florida, and specifically the Tops case, the Tops case states that it's res judicata, which means in Latin the thing adjudicated, and it says for an issue to have been truly decided, the ruling must be on the merits. And here we have no ruling from a court. We have the plaintiff that initially tried to voluntarily dismiss without prejudice, which in state court they would have been allowed to do right up until trial. But in federal court, they did not get leave of court to dismiss without prejudice, therefore they're forced to dismiss with prejudice.
Counsel, did you have an option under the federal rules to continue forward with your case?
Yes, the judge, it was set for trial in September. The fear was that we could not get a key piece of evidence into the trial because it was on a tug that was hauling oil freight between Tampa and Louisiana. And as a matter of fact, those parts were eventually removed, but that was January of the following year. And so those parts that would have been needed for the first trial wouldn't have been available, which is why the plaintiff made the strategic decision to dismiss the case with prejudice. It was set for trial and we could have gone forward, but the plaintiff chose not to go forward. But the Tops case, again, says the ruling has to be on the merits. And another case out of this court is the Holt case, which was a case about motorcycle parts. And in that case, the plaintiff sued the defendant for replevin in county court for return of his motorcycle parts. He won the case. And then he brought a separate action for conversion of the motorcycle, of which parts he had just won recovery on. And this court held that is not res judicata because it is not the same issues. You have the parts of the motorcycle and the whole of the motorcycle as two separate issues, so they allowed the plaintiff to proceed in both cases. This is the same thing. While it's the same contract and the same parties, those are two of the four necessary identities. The other two identities are not present. While the cause of action may be styled in identical terms, breach of contract, unjust enrichment, they don't arise from the same wrongful act. And so because the wrongful act is different, the plaintiff should be allowed to proceed in this court on those wrongful acts and obtain a recovery. It would be inequitable to allow the defendant to gain from the fact that they got dismissal in the first case on a differently alleged wrongful act as opposed to the wrongful act they committed in this case. Even the case that the defendants relied on at the hearing was the Amick case. And the Amick case even talks about a full and fair opportunity to litigate the issues. Again, that never happened in the federal court. The federal court, there was never a trial. The defense points to the summary judgment. It was granted in part and denied in part. The case was going to trial. The part that it was granted to was as it related to privity with the plaintiff's customer. The court ruled that if there was a claim, it was for the plaintiff's customer to bring the claim against the defendant and not the plaintiff. But the court did let the parts that the plaintiff did buy from the defendant for use in another customer's tugboat to continue on to trial. But again, the plaintiff decided that it couldn't bring it to trial, tried to dismiss without prejudice, was denied by the court, and then dismissed it with prejudice. And so the first case, the wrongful acts that gave rise to the claim are fraud and misrepresentation. That's not alleged anywhere in the second case. The second case simply said, we had a contract. I buy the parts from you. I return you the parts I take out from the other ship, and you give me a credit towards that and send me money back as soon as I send you the parts. Kind of like if you buy a 5-gallon jug of water, you pay a deposit. When you return the empty, the deposit is returned to you or credited towards your next purchase. That's exactly what happened in this case. Parts were bought, the originals were returned, and no money was tendered back to the plaintiff. And so in October of 2011, the plaintiff issues a credit memo to the defendant, and the defense makes a big issue of, well, questions in the federal case at depositions were asked about the credit issues. Well, yes. You have the guy there in front of you in deposition, you're going to ask him some questions about their refund policy since your client still hasn't received a refund. Doesn't mean they're not going to. And the plaintiff was always on the presumption that the reason no refund is forthcoming is because the parties are in litigation. And so once the litigation is over, the plaintiff says, okay, now we'd like our money for the parts that we've returned. And they're told, well, there's other charges against it, and so you're not going to get back the money. And that's when the second suit is initiated. And I think the adjudication on the merits really arises from the differences between the federal court and the state court. Because in state court, you can dismiss without prejudice at the close of plaintiff's case at trial. And you can then relitigate the issues because there's no ruling on the merits. In the federal court, the only time you can dismiss without prejudice without leave of court is prior to an answer being filed. And as we all know, the answer is due 20 days after the complaint's filed, and after that you need leave of court. And it was sought. Leave of court to dismiss without prejudice was sought in this case, and it was denied by the federal court. And so I believe that res judicata is not a proper grounds on which to dismiss this case. The plaintiff should have a chance to move forward on the merits and be able to prove its case at a trial. The other issue that the defense raises is splitting of actions. And splitting of actions would mean that if you, I believe the case that's cited cites to a car accident case. And so if you have a car accident, you sue for personal injury, and then after that case is over, you sue for the property damage. Well, obviously all the damage is accrued from the same car accident, so they all had to be brought at the same time. That wasn't the case here. The case here was parts were purchased, and then a lawsuit commenced as to the genuineness of those parts. Not as to, we're going to return parts, we're not going to return parts, you're going to give us a credit, you're not going to give us a credit. That wasn't the issue. Then parts are returned, and the plaintiff makes a demand for the payment back up that they're due, and they're told you're not going to get it. That's the second cause of action. It wasn't ripe at the time the first cause of action accrued. And I think the answer brief cites to a paragraph in the federal complaint that talks about a charge from the defendant to the plaintiff. That's not the refund. That was referring to spares and court chargebacks as to spares, and it talks about $9,900. This is a case over $16,000. The other issue the defendants raised at the hearing is, why spend so much money to recover such a little sum of money with the litigation? That's an issue for the plaintiff to take up, whether it's economically viable to spend money on a case where you're going to win less amount of money is a strategic decision. The plaintiff can make a decision to do that or not to do that, but that's not for the defendants to say, well, it's not enough money to sue on, so therefore it's clearly should have been brought in the first case. The first case was a completely different set of facts. It was based on the issue of, you told us what we're getting and we didn't get it. That's all. There was no, and you owe us money back for parts. That wasn't part of any of the counts in the first complaint. The second complaint is very simply, we returned parts to you, we'd like the money for the parts that we returned, and you didn't pay us back. And so there's no splitting of actions, there's no res judicata, and we'd ask this court to reverse the summary judgment and remand back to the lower court, consistent with the opinion. Thank you.
Thank you, Mr. Siegel.
May it please the court, Mark Tinker and Alan von Spiegelfeld on behalf of Marine Systems. I think the key to this case is the question you asked, Judge Crenshaw, is could they have continued on to trial in the original federal court case? And yes, they could have, and more importantly, could have on this exact issue, this question of the returns of the chargebacks. I put it in the brief for the court. It's on page 51 of our record, which is the original complaint that was filed in that federal court action. Paragraph 17 specifically raises that as an issue in the case. It says that the defendant has failed to credit Transmarine for the expense for these returns, the core charges. So it was pled. As counsel mentioned, it was a subject of discovery. Back in 2012, the general manager, the service manager, the customer service manager were all called up for deposition. They testified about these chargebacks, about the returns. So it was there, it was at issue. If the original federal case had gone to trial, they could have raised that issue. It was pled, it was there for litigating, and the fact that they chose to dismiss with prejudice, that doesn't mean that they can just come back and refile it now a second time. I've provided for the court cases both under Florida law and under federal law in the 11th Circuit. A dismissal with prejudice is an adjudication on the merits. It prevents relitigating in a second case for res judicata purposes. And then even if that wasn't the case, the splitting causes of action issue, this is whether we're talking about did you deliver the right part the first time or did you provide the refunds for the ones we returned? That's all breach of contract, and more importantly, it's allegations of breach of the same contract. There's this 2009 purchase agreement. It was attached to the complaint in the original federal court action saying this is the contract you breach. In this case that was refiled, same contract was attached, identical allegations, this is the contract you breached. That's an issue that can't be relitigated. And I think the issues are very straightforward. Unless the court has any questions, I'll simply yield my time. Thank you.
Thank you, Mr. Tinker.
May it please the court. I think it's important to read the words that counsel just referred to, and I'll read it. It says, TMT sent a written notice to defendant that it had incurred $9,961.50 in cost to Marine Systems regarding core charges for spares returned to Marine Systems. To date, the defendant has failed to credit TMT for this expense incurred through no fault of TMT. That was in the general allegations part of the paragraph. When counsel says they could have continued the trial and they could have tried the issue, that's simply not true. The only way to do that would have been to seek leave to amend to add a cause of action for a second breach of contract. And again, leave of court was not granted to amend the complaint for any reason. And so whether or not it could have been brought, it could not have been brought up at the first trial, because while it was in the general allegations, they could have just simply issued the credit any time during the pendency of the case and put that matter to an end, and the plaintiff wouldn't have had a cause of action. But after the case,
What was the purpose of that allegation?
just to show the continual wrongdoings of the defendant. The defendant was charged with fraud and misrepresentation, and so in continuing the pattern of behavior, the plaintiff sent him a notice that you're charging us $9,961.50 when we return the parts to you. That, you should credit that back, and the amount sued on is not that amount. The amount sued on is over $16,000 because there was more than one return. There was 3 invoices attached to the credit memo that was attached to the complaint in the underlying court. So I don't believe that the matter could have continued to trial on the issue of the money owed, because that was not raised in the original complaint. So even if there was a trial, win or lose, I don't think it bars this issue from being brought up in the second case. Thank you.
Thank you, Mr. Siegel. Okay. Next case is Anderson et al. Versus Mosaic Fertilizer.